Okay, welcome to today's lunchtime webinar. We're going to talk about estate planning today. Some of the basics, but some things that I find that even those that have estate plans set up don't have or are missing. So this is, again, sort of a good checklist to make sure that your estate planning is in order. Last month, we talked about your corporate planning. So make sure you go back and watch that video on corporate planning. Which is sort of organizing your business life. And today's webinar is on organizing your personal life. But of course, since the work we do is a lot of corporate stuff, it is how to incorporate your businesses, your LLCs and your S-Corps into your family estate plan. Because I find, in fact, I found almost exclusively that most of my clients have not done that. So, and we'll explain why. Okay. Let's see, how do I get to the next slide? There we go. Obviously, you've all heard this before. Today's presentation materials are copyrighted. Please no unauthorized reproductions, and you don't need to copy this and send this out to anybody because it's available free on my website. So just go to the website and watch it. Again, thanks for listening in today. We hope you find it interesting and informative. This is general advice and education. It's not to be considered specific legal advice for your situation, but just something to make you a more informed individual about today's topic, which is estate planning. And if you have any questions or concerns, feel free to contact the office, and we will answer your specific question at that time. Okie doke. My background, all of you, actually there's a lot online that don't know me, or at least names that I don't recognize. So I've been an attorney since 1995. That puts me at 19 years, coming up on my 20-year anniversary next May. Created over 500 business entities, worked with over 700 clients. Since most of you are real estate investors, I've been a real estate investor since 2000. I was a licensed real estate agent for 8 years. I do title and escrow. I've been an entrepreneur, started numerous businesses, been a business consultant and educator, member of many RIAs and associations and nonprofit organizations where I've been on the board of directors and board of trustees, published author, 3 novels, and former coach and athlete, hoping to be another athlete again, getting back in shape. That's my New Year's resolution for 2015 on top of making sure my business life is all taken care of. Okay, what our office does, entity formation, asset protection, estate planning, title and escrow, business and real estate transactional documents, and of course, live education through webinars, which is what we are doing right now. Okay, let's get into the meat of this so that you can get on with your lunch or back to work. Again, most of these run about 30 to 45 minutes, so we'll get started into today's topic, which is family estate planning. Here's a checklist of the documents that you should have for your family. A family living trust, a pour-over will, power of attorney, healthcare directives, and your corporate succession documents. Okay, so those are the 5 topics or 5 documents we're going to talk about today in a little bit more detail. But there's a good checklist. Make sure you've got all of those things in your family estate plan. So the very first thing is the family living trust, and this is probably the most important document that you will need because it is the controller. It's the one that really dictates what is to happen with your estate. A family living trust. Now, if you've obviously listened to many of my webinars and seen me teach, there's a lot of kinds of trusts. And I create a lot of trusts here in the office, living trusts, land trusts, etc. And so what we're talking about today, just for clarification purposes, is the family living trust. It's a very different document than a title holding trust or a wholesaling trust, which are other types of trusts that we do here at the office. Okay, this is an estate planning document. It is something that for most Americans do once, and then it's sort of good for the rest of their lives. There are situations, particularly if your estate grows to a much larger level, you may need to either get a new type of trust or do some major revisions on your trust. But 90 to 95% of all Americans really benefit from what we call a grantor or family living trust. The descriptions here is 1, 2, 3, and 4. These are grantor trusts. And what this means is that the grantor, who is the person that creates the trust, so it's you, okay? When you create a trust for yourself or for your family, you are the grantor. So you created this trust. And as a grantor trust, the grantor is responsible for all taxes that it might be associated with the trust. So the trust itself doesn't file a tax return and doesn't get an EIN. It just sort of is a conduit. And anything that kind of flows in and out of it for tax purposes flows right onto the grantor's tax return. Okay? So a family living trust does not file a tax return, does not get an EIN. That is until you die. And once the grantor is dead, then this becomes a completely different kind of trust. It actually becomes an irrevocable trust, and it does get an EIN and it does file tax returns. But while you are living, this is a grantor trust. It is revocable, which means you as the grantor can change it, modify it, cancel it, amend it any way you want at any time. It is completely modifiable. So it's something that you should, and I recommend, once a year, and this is December, November, December is a great time to do this, review your family trust documents, and ask yourselves, what changes have been made in my life over the last year? Did I start new businesses? Did I acquire new properties? These sort of things. And review your trust, understand it, and then if you need to make changes, you can make changes. And that's why we're doing this webinar today. And it's inter vivos, which means it's among the living. This is a living trust, family living trust, and it's revocable during the life of the grantor, and it's an agreement between living people. And like I said, once the grantor dies, this trust becomes irrevocable and a completely different matter. And then at that point, it cannot be changed or modified, or at least not very easily. There's also a difference between estate planning and tax planning. Estate planning is really, in the way I use the term, and different lawyers use it differently, is really planning for your estate so that there is a mechanism by which you can allocate your assets easily, efficiently, less expensively, and privately when you die. And that's what the family living trust is really for. It's to avoid probate. Sometimes they're called probate avoiding trusts. It is to keep your family wishes private, and it can speed things up and cost you less to have your estate handled when you die, as opposed to having to go through probate, which is a public court proceeding. Then there's tax planning. This really kind of comes into, and a lot of attorneys call this estate planning, but this is when families have large estates, and by large, I mean high value. There is an exemption from estate tax law. As you all know, there are estate taxes. And when you die, your estate, the value of your estate that transfers to your children or to your heirs, is subject to estate tax. Now, there's an exemption or amount that is tax-free. It's kind of like for those of you who ever sold a personal residence and you realized that you could sell your personal residence and get the equity out of it, tax-free up to $250,000 as a single individual or $500,000 as a married couple. That's an exemption. So normally the money that you made on the equity of your house would be taxed, but there's an exemption up to a certain level, and so you were able to take that money out tax-free. Same thing is true in estate planning and with estate taxes. There's an exempt amount, and right now it's about $5.3 million as an individual, which makes it about $10.6 million for a married couple. So right now, you can leave a large estate tax-free to your children and to heirs. There are a few nuances with that, but that's a good sort of baseline understanding that, unless your estate is over those amounts, then tax planning isn't your biggest consideration. As you get closer to that, maybe a $1 million estate or $2 million estate, even though that's still pretty much all tax-free, then there are some issues that you'll want to start thinking about for tax planning purposes, not just the allocation of assets upon your death, but how to allocate those assets in the most tax-advantaged way. I think it's 98 or 97% of Americans, or 90, maybe even higher than 99% of Americans, don't have estates over that limit. So for most Americans, tax planning is normally not a consideration. But for you guys, just to be aware of that. If you have estates that large, feel free to contact the office. But for most of what we're going to talk about for the next 20 or 30 minutes is really estate planning, where we're looking at making sure that your family's estate is handled quickly and efficiently upon your death. Okay? A couple more things about the family trust funding. This is the most important thing with your family living trust. It must be funded. What do I mean by funding? You must transfer assets to the name of the trust. And in Utah, it's actually in the name of the trustee of the trust. So anything with a title, real estate, cars, if you want the trust to control that asset, then the trust must own that asset. If it doesn't own it, it can't control it. And that is a large problem with a lot of families that set up family living trusts. They get the trust, they get instructions on, okay, here's your trust, now you go and, hold on one sec. Oh, I just got a little pop-up saying the audio might be bad, but now that pop-up is gone. So for those listening, if you do ever hear any kind of audio quality issues, just please let me know and I'll keep an eye on the question screen. But it looks good now. And the families forget to transfer title to the name of the trust. So that is something very, very important, which, in this end of year review of your life, make sure you've done that. Personal residences, stock options, mutual funds, life insurance policies, retirement accounts. For the most part, there are some issues with retirement accounts, and we'll talk about that in a minute. All of these things should be titled in the name of the family trust. Okay, so make sure you've done that. We're going to talk a little bit more about that as we go on. And a yearly review, like I said, every year you should sit down with your family, with your trust, and think about these things. And just keep an eye out for the checklist that I'll be sending out in the next couple of weeks, which will help you do your family review. Okay, sections of the family trust. There's obviously a lot of stuff in the family trust, and they're pretty consistent throughout all the ones that I see from many, many, many different lawyers, and they all contain a lot of the same general information and clauses. Now, there are some things that I think you should make sure that are in your trust, which I always stick in mine when we create them. And some of these are issues that affect my clients, which is why I want them in their family trust. And a lot of estate planning attorneys don't understand or don't work a lot with the truly self-employed, particularly real estate investors with real estate holdings. And their guidance would be very, very different. Their recommendation would be very different than the recommendation I give. So first, a special needs trust, and this is also very similar to the situation of a beneficiary who's getting divorced or has debts. Your trust should allow the trustee to set up specialized or special needs trusts underneath it. And this could be in the event that one of your heirs or your children that you want to leave stuff to is incapacitated or injured, or even in a life position where they're just not able to handle the money. And rather than distribute it to somebody who's not in a position to handle it, the trustee can set up a special trust, distribute the money to this other trust. So the individual is actually getting it in another trust, and that trust will hold it until that person is able and willing to take the money. And this can be done also if one of the beneficiaries is getting a divorce and the ex is trying to go after assets, or if one of the beneficiary has a lot of debts and there's a court coming after what the beneficiary might receive. in that case, the trustee can then withhold those distributions and keep them from the divorce court or the other court, and just kind of hold on to those, or set up a special trust where those assets would be held until that beneficiary's debts and divorce are done. So that's just a way of controlling assets in the event of unique situations. And I'd say most trusts that I see have those clauses in it, but not all. Some trusts I see are very, very simple and straightforward, which is good because at least you've got the document, but there are some definitely things that you can put in there. Question, how to put a car in the name of the trust and the car is already owned. So that's a question, thanks Emily. You can certainly title the car in the name of the trust. I'm not a huge fan of that. A car is really a depreciating asset. It's generally not worth very much, and it can be, we're going to get a little bit longer about, when we talk about this pour over will, and it can run a lot of liability. And so if you have like special cars, expensive cars, antique cars, the kind of, things that have value that you really do consider part of your estate, yes, you can put those into a trust and you can title them in the name of the trust. If it's just your family car that you're going to, keep driving and driving and driving, I'm usually sixes on whether or not you put it in the trust. In fact, I'm fine not putting it in the trust because it's really not an asset that's going to be of value to your heirs at that point. Like you probably won't even have that car when you die. So again, there's my answer on cars. My kids will be able to own it. Oh, God. Pour over will. We'll get to the pour over will in just a minute. Okay, retirement accounts. There's a lot I always recommend here, if you have IRA accounts, every IRA account has to name a beneficiary so that if you don't use your IRA before you die, the IRA can go to somebody. Now, if it goes to an individual, another human being like a spouse or a child, then that person can decide whether or not to take out the money from the IRA account or leave it in the IRA account and let it continue to grow tax-free. Now, a lot of clients with large IRA accounts and realize that they're going to leave some of this retirement money to children are concerned about this. Because if your retirement account goes into a trust, if you name the beneficiary as a trust does not have the option to leave the money in the IRA account. It's got to take it out within 5 years. And there are qualified trusts which can keep that human being exception to having to withdraw the money. And it generally has to be an irrevocable trust, which happens when the person dies. So for most people, you can name your trust as the beneficiary on your retirement accounts, but it's definitely something you want to look into and review with me. And your trust can actually state that in the event of your death, then this trust will be allowed to maintain the money in that IRA account and let it grow tax-free without having to withdraw it within that 5 years. So that's something you definitely want to think about, is your retirement accounts and your trust and how to list the beneficiary on your IRA accounts. Closely held businesses and subchapter S trusts. These I almost never see in the trusts that I see from other clients. Because a lot of the attorneys that set these up, they're thinking more along the lines of a standard family. Most families aren't self-employed. So most families don't own LLCs and series LLCs, and they're S corps for their flipping and their wholesaling. And so their trusts don't really dictate what's to happen. Now, most estate planning attorneys would say, okay, you've got an LLC that owns property, that's great. We'll just make the trust the owner of the LLC. And that way the trust owns the LLC, and when you die, the trustee of the trust can then take over the LLC. That's great, with the exception of if your trust owns your LLC, there's no asset protection there. and all of those properties are at risk if something happens to the grantor and the grantor is sued. So I never recommend the LLC be owned 100% by the trust. So what do? Well, we're going to talk about our corporate succession documents in a minute, and that's the one thing we do. But we also include in our trusts language that allows the trustee to keep these businesses running. Most trusts dictate that, upon the death of the grantor, then assets are kind of liquidated and distributed, because the trustee really isn't in the position to run a real estate business or property management business or deal with the wholesalings or the flips that are ongoing. And so they just kind of leave it out. So when we create language in our trusts so that the trustee can actually maintain those LLCs up and running and not have to liquidate them, and can run those businesses as the manager and step in as the manager of those LLCs. And the same thing with the subchapter S. These are your S-elected LLCs or your quote-unquote S-corps. A trust cannot own an S-corp. I don't know how many of you knew that, but an S-corp can only be owned by a human being who's an American. So your trust can't own your S-corp anyways. So what we do is we put in language in the trust along with our corporate succession documents, which we're going to talk about, but language in there that says, in the event that this trust ever has to take ownership of an S-corp, then it will create what's called a QSST. So the trustee will actually just create this separate trust, which is called a qualified subchapter S trust. That's the QSST. And this other trust that's created by the trustee can then own your S-corp and keep your S-corp up and running and engaged in business for as long as it wants. It doesn't have to just liquidate it because it's no longer run by you. And then the final thing that we generally include is the option for what's called a trust protector. The trust protector is somebody not the trustee. Most likely the trustee on your trusts are going to be a family member, a surviving spouse, children, or somebody like that, right? That's pretty much how most of you will have your family trust set up. But your child may not know exactly what to do with the retirement accounts or your LLC assets or your S-corp and your flips and your rentals and your self-directed IRA LLCs, right? These things aren't exactly, elementary things. That's why you guys have been educating yourselves and listening to me speak all the time to teach you about what these things mean, how they're used, how they work, and how to run them. And your child, or whoever becomes that trustee, may not understand that and not have the sophistication or the education to be able to continue on with what you want to have happen when you die. And that is, you maybe want these assets to continue to grow and grow and grow for future benefit. And so what a trust protector does is it allows the trustee to hire somebody who understands these assets and these businesses kind of as an advisor. And you can make this trust protector even give them approval over what the trustee does, so the trustee can't do things on their own. It's also used very often in situations where you're not sure about your trustee. You're not sure if they're going to allocate your assets the way you want them. Maybe they'll just liquidate everything and take it and run. So trust protectors can also be used to oversee the trustee. And these are generally hired positions, and they're generally professionals, attorneys, ex-judges, estate planning attorneys, business advisors, financial planners are very often trust protectors. So there's a lot of options to name those. You can actually name the trust protector in your trust, or you can give the trustee the option to appoint a trust protector. So those are some of the sections you should have in your trust. So good review for you for the next month to pull out that old family trust and dust it off and actually read it, because you probably haven't read it since the day you signed it. Okay. Let's see. Next slide. Okay. The pour over will. what is this? This works in conjunction with your family trust. So you need to have a family trust in order to have a pour-over will. If you don't have a family trust, then all you have is a will. And what it does is it captures anything that's not in the trust and then pours it into the trust. So a lot of people think, oh, well, I've got a pour-over will, and so I'll just let everything be in that, and I won't worry about titling things in the name of my trust or moving things over to the trust ownership because my pour-over will capture it. Not true. The pour-over will does not avoid probate, so there's still the importance of funding your trust. As a will, it must be witnessed by two people, which a trust does not. And what it does really is it allows you to be a little bit more specific with things, personal items, maybe some jewelry, gun collections, furniture, grandma's old rocking chair, things that probably don't have a whole lot of intrinsic value from a dollar amount, but an emotional value that you may want to leave to certain individuals. And it's kind of hard to title a rocking chair in the name of your trust. So that's really what the will is. And what it can really do, if you really fund your trust and you really understand your estate, if you keep all of your major assets in the trust and what's left in the will is less than $100,000, in the state of Utah, this is called a small estate probate. And you can actually get an exception from the probate process. You fill out some forms, give them the suggested value of the estate, and you can get the authorization to immediately proceed as the administrator of this will and pour it all over into the trust because the estate's less than $100,000. So the suggestion always is make sure that your major assets, where most of the value is, ends up either is titled in the trust or ends up in the trust automatically, and keep everything that might end up in the will portion less than $100,000. And then you can use the small estate probate exception, and really, I think you do that in a couple of weeks, and doesn't have to go through the public process. The question is, if I have a pour-over will my kids be able to own it after I'm gone? Yes. If you leave the car, if you list the car in the pour-over will, and cars are exempt actually from this $100,000 limit. So if it's listed in the will and your estate is less than $100,000, you go through this quick small estate probate route. Then it immediately becomes part of the trust, and the trustee can then distribute that car or the grandma's rocking chair or the gun collection or the antique books to whoever is listed in the will or the trust. So that's kind of, that's kind of how those two work. Okay. Power of attorney. Here are some different kinds of powers of attorney. Generally, when we set up estate planning set of documents, we include powers of attorney, and they're generally a general power of attorney. And this covers everything. I mean, it pretty much allows whoever you name as your attorney, in fact, the right to do just about everything in your name. Get access to savings accounts, sell property, deal with banks, whatever it is. It's 6 or 7 pages long, and it literally covers about everything you need done. A special power of attorney only covers listed duties. For example, you can have a special power of attorney that allows somebody to sell a piece of property for you. You list that property, you list the legal description, and then that person, the only thing they can do on your behalf is sell that one piece of real estate. They can't do anything else in your name. A springing power of attorney is one that begins with incapacity. So this is a power of attorney that you can sign, name your attorney in fact, but it isn't effective until you become incapacitated. So you're in a coma, you get sick, you become mentally disabled, become physically disabled, and you can no longer act on your behalf. At that point, that springing power of attorney kicks in, and that attorney, in fact, can then act on your behalf. A durable power of attorney is one that doesn't end with incapacity. So most power of attorney are good while you are sane and physically capable. they're created really for efficiency purposes, so that somebody else can act on your behalf simply because you aren't around. Maybe you're traveling, or you don't have time, and you want somebody else to go deal with things. But a durable power of attorney would extend beyond your incapacity. So even after you're in a coma or physically or mentally incapacitated, that power of attorney still works. So there's different kinds. We generally, for estate planning purposes, you will have a general power of attorney, which will be durable, because that's really the point of an estate planning power of attorney, is you want somebody to be able to deal with your estate if you're incapacitated. And they're either springing or not. Sometimes we'll create powers of attorney that are available and effective immediately, others that will begin when the main person becomes incapacitated. Now, one thing to note, all POAs end with the death of the grantor. And this is something I find a lot of my clients don't understand. All POAs, whether it's general, special, springing, durable, or any other kind, they always end with the death of the grantor. I've had clients call up and say, oh, yeah, well, I got this property I want to buy, and the seller's dad just died, and it's in the dad's name, but but his daughter has a power of attorney and she wants to sell it to me. Yeah, no, that's not going to happen. As soon as the owner of the property died, that power of attorney died with him, and that house is now in probate until the court appoints an administrator, and then that administrator can sell the house. So just be aware that powers of attorney do not extend past death. Okay. Healthcare directives. These are pretty straightforward, and they're actually form documents from the state of Utah. It allows somebody to make medical decisions on your behalf, to decide what treatment you get. If you're in surgery and the surgeon comes out and says, okay, we found, we went in to do a hip replacement, we found cancer. What do you want us to do? Do you want us to take out the cancer? So medical decisions, it allows somebody to make life-ending decisions. This is often called a living will, which allows somebody to pull the plug on you, to be blunt. That's what the living will does. It gives someone the authority to end your life under certain circumstances. HIPAA release. Remember, most medical records are private and cannot be released without some sort of documentation that you are authorized to receive them. So you should have a HIPAA release. That way you can get your loved one's medical information in order to make these decisions. And generally, these also come with final disposition instructions. So on your death, what do you want to have happen? Do you want to be buried in a certain plot next to your parents? Do you want to be cremated? So it generally has final disposition instructions as well. And so these are, again, documents that you really kind of want to just have in the event. You don't think about these things until they come up, and once they come up, it's too late. Once somebody's in a coma, they can't sign a healthcare directive. They can't sign a POA. They can't sign a trust. So these things all have to be done, sort of when things are good, and when you're not thinking about dying. That's the best time to do these. Okay, corporate succession documents. In the next couple months, go through, just put a list of all of your LLCs, and make sure you've got transfer on death agreements for all of these and all the members. What this does is this transfers your membership in the LLC or your ownership of an S Corp or S elected LLC to the family trust upon your death. All right, these are valid agreements that kick in when you die. And what happens is it avoids probate, because these are essentially internal corporate documents that are agreements among the members that say, when I die, I want it to go to the family trust. And that way, while you're alive, you can keep that multi-member LLC and keep that asset protection. But when you die, then the trust owns it, and then the trust can immediately allocate the assets or manage the assets or do whatever you want to do with the trust. And same thing with the S Corp. Again, if necessary, the trustee can set up a special QSST to take that ownership. But as long as you've got these transfer documents in place, these will kick in without having to go through probate, while at the same time maintaining not only the asset protection while you're alive, but the ease of management. If your trust owns an LLC, then the trustee is acting on behalf of the trust, as the manager of the LLC, and suddenly you're like, how in the crap do I sign documents when the owner is a trustee of a trust? So it can get a little confusing. It makes things much easier to keep your LLCs multi-member, manager managed, with good transfer on death agreements, which will transfer those LLCs or S corps or other business entities. Partnerships, worked with your partnership documents. If you have a family limited partnership, you can transfer your partnership interest to your trust as well. So great document to have. Highly recommend it. That will make things much, much easier when you die. Okay, that's pretty much it. Just kind of a reminder that on December 2nd, we're talking about improving efficiency in your business. So you all get my emails about once a week. Just make sure you click links and register for that. And right now I will stick around for some questions on family trust or the associated documents. So if you got a question, you can raise your hand or type in a question in the little question box that you should be seeing. And I will just hang out. Wow, I must have done a really, really good job of teaching. Okay. Mr. Catch, I just unmuted you. So if you have a microphone, if you're at your computer, you should be able to ask your question. I don't hear you. So maybe you're not at a computer. You do need to be at a computer with a microphone to ask a verbal question. So Jeff, since I can't hear you, if you want to just type your question, that'll be great. Wow, okay. I'm going to stop the recording right now, but I will stay online for a few more minutes to answer questions. So just stopping the